You're Marcus Elam? And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation on probation for burglary of a habitation.
Quick legal breakdown. Marcus was on unadjudicated probation for burglary of a habitation, which means if he followed the rules, he'd avoid a conviction, but mess it up. The court can bring the full felony charge crashing down. Spoiler alert, he messed up a lot.
Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete his probation given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Let's pause for a second. Notice what just happened. Marcus makes a heartfelt plea, wants a do-over, and brings up family, grief, and redemption. Classic mitigation tactic. But is the court buying it? Jury's still out literally and figuratively.
You're okay. And everything else, Sean.
Okay.
And Judge, I'm sorry. I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point, my understanding, Judge.
What is the status of the 5 new offenses that are alleged?
5 new alleged offenses while on probation. Yikes, this is where most judges start losing sympathy. It's not just one slip-up, it's a pattern. And when a judge hears deadly conduct and discharging a firearm, they start reaching for the sentencing guidelines.
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
He pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Anna, can you tell?
I'm sorry, Judge, I didn't look him up after he pled through.
I know, I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
There was an obstruction in 2023 that was dismissed.
Birthday, gentlemen. Just said unlikely to prove.
I mean, he pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or refused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation.
Here comes the real kicker. Even though Marcus avoided felony convictions, he still pled true to several offenses. That's enough for the judge to act heaven if the DA hasn't landed a conviction yet. In probation cases, your own admission can seal the deal.
Dead for him, and eventually he timed out of that, or something happened and the new offenses came up and they would take him?
I think when he had the prior MTRP, I don't know if it was at the new case or a prior MTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral recognition therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
You get an opportunity to be on probation for a burglary of a habitation, and I want to really make sure I've got this right. So you get deferred probation for burglary of a habitation, second-degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same date. Regardless of what's come of those cases, you've admitted that something happened on that day, right? So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISF. But because I guess something else must have been pending, maybe misdemeanors or something, you don't go to ISF. So you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know, I mean...
This moment is brutal. The judge is clearly fed up. She lays out the timeline: 3 chances blown, new crimes, and then disappearing for nearly 2 years. It's not just legal failure, it's personal disappointment. You can hear it in her voice.
Growing up and making better decisions.
And I think Ms. Isaac tried to work with him when he would show up to work with her. So, I mean, I don't object to revocation, Judge, and any opportunity that we've given him.
I mean, I don't know that it makes sense for me to do anything else. And it's just so frustrating, honestly, for me, for the young people to keep coming in here with offenses that have to do with shooting. While you're on probation for a felony, you're shooting. Then you get out again and you violate again and you take off. So I can't give you a 4th shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff. Good morning, sir. You're Chad Michael Holland. And Mr. Holland, in cause number 24, DCCR 1616, you're charged with the 3rd-degree felony offense of fraudulently securing documents by deception, but it says executed documents. Anyway, and that offense is from December 30th of 2023. Your indictment alleges that you were previously convicted of burglary of a habitation March 15th of 2004, and after that was final, you were convicted of fraudulent use of identifying information October 7th of 2020, and also possession of a controlled substance, a 2nd-degree felony, October 7th of 2020. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 25 years up to 99 years or life in prison. Do you understand? Yes, ma'am. And I have a plea bargain rejection here that shows that the district... What's going on over there? Everybody needs to, if y'all are going to be here, you need to sit up straight in your seats. We can get you a comfy seat up here if you want to come be closer to the action. But if you're going to be here, you don't sleep in court. That's disrespectful, okay? So sit up. Get your hand off your head. Everybody sit up. Eyes open. Pay attention, please. So I I have a plea bargain rejection that you've signed with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty, and that would be pleading to counts 1 and 2 only, for a 15-year term in the institutional division of the Texas Department of Corrections. Do you understand what your possible consequences are if you go to trial and what your options are?
Yes, Your Honor.
And do you want to reject that offer and have your case set for trial? Yes, sir.
I'm sorry to interrupt you. I'd like to point out that that 15-year offer was a one-time today on the offer. I communicated that to Mr. Gertz that I would waive one of the enhancement paragraphs or a couple of the enhancement paragraphs to get us to that 15 to 99 punishment range. But,
Okay.
I have every intention of proceeding on the habitual offender
Sure.
if we go to trial.
And y'all talked about that. And so, Mr. Holland, I want to make sure you understand that after today,
6 years in prison. No more probation, no more chances. And here's a big one. Marcus just lost his right to possess a firearm for life. That's a federal consequence of a state-level felony. Think about that before calling it just a burglary case.